If the members would please take their seats and log into the system. Members, please take your seats and log into the system. Will the members please take their places and log into the voting system? Good afternoon. Today is Wednesday, April 1st, 2026. I hereby call State and Local Government Committee to order. Madam Clerk, will you please open the board for roll call? Does anyone need more time? There you go. All right, Madam Clerk, please close the board and announce roll call.
Mr. Chairman, you have 19 members present. You have a quorum.
We have a quorum. Do any of the members have any personal orders or announcements? Chairman Rudd.
Thank you, Mr. Chairman. I would like to recognize my two shadows today, if you'll stand, Jet Shah and Palu Gofo.
Any other announcements? Seeing none, we will move forward. Today we have 76 items on the agenda, and so we will do our best to knock these out. And you'll see members getting up and down, going to other committees to present their bills, and people coming in the whole time we're in committee to present their bills. But we'll be jumping around trying to take up some that we have put off for a while. We're going to start with item number 6 on today's agenda. This is Representative Brock Martin. Got a proper motion in second. This is House Bill 2281. I do see we have some amendments. Can you please give us your drafting code?
Yes, Mr. Chairman, 016377.
Proper motion in second. Would you like us to place that on the bill for discussion?
I would, yes, sir.
Without objection, we'll place amendment number 16377 on to House Bill 2281. All those in favor, please say aye. Opposed, no. Your bill's now amended. You're recognized.
I do have another one as well, if you want to add that one in.
Okay.
016915.
Proper motion in a second on the amendment. Without objection, we'll place amendment 16915 on to House Bill 2281. All those in favor, please say aye. Opposed, no. Your bill's amended again, so
That's
you're
right.
recognized.
And we'll roll that all into one, if you don't mind to make the bill.
Without objection, it'll be rolled into one.
There we go. Now we're ready. This legislation's primary goal is to expand statutory access to agency data and records for key legislative oversight bodies while continuing to safeguard confidentiality of such information. The legislation improves transparency and accountability in state government, making sure legislative oversight has the tools and access needed to analyze budgets, expenditures, impacts of legislative proposals, program performance, and financial records for our legislative body. This also has the two amendment code components, clarifies which and what records we can receive, as well as ensuring privacy with criminal criminal privacy records are kept secure for the criminal justice process. With that, I stand ready for question.
You've heard the explanation of the sponsor. Are there any questions for the sponsor? Representative Warner.
Thank you, Mr. Chairman. Sponsor, just curious, where did this bill come from?
Sponsor, you're recognized.
The speaker provided me with the bill, so.
The speaker, 10-4, 10-4.
Any other questions for the sponsor? Representative Dixie.
Will part of this program or software, would it include a database for a statewide database for the criminal justice system, so all law enforcement agencies across the state can communicate and know what's going on in each jurisdiction? So if someone had a warrant in or charges or convictions in Shelby County, that they would know in Knox County as well?
Sponsor.
I don't think so. This is more on transparency component of what's going on within their agencies on spending and aspects of that. So we're really looking at making sure that they're spending the money the way that we're allowing them to do it and making sure transparency is occurring there. But I'm not familiar with that aspect of it.
Yeah, I think
You're recognized.
I think this is a good idea, but I also would hope that we could move toward that one day. I think that would be very beneficial, especially to our law enforcement agencies, and ways to move forward, and we can kind of move the judicial system forward into at least to the millennium. Thank you.
Yes, sir.
Any other questions for the sponsor? Seeing none, we're ready to vote on House Bill 2281. Moving on to Finance, Ways and Means. All those in favor, please vote yes on the board. Those opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 20 ayes and 0 noes.
Bill moves on to Finance, Ways and Means.
Thank you, committee and chair.
Item 21. We have Chairman Todd, and we got a proper motion and second. And I do see we have some amendments. This is House Bill 889. Please give us your drafting code.
16863 is the one I would prefer, sir.
That's correct. Without objection, we'll place Amendment 16863 on to House Bill 0889. All in favor, please say aye. Opposed, no. Your bill's now amended. You're recognized on your amended bill.
Thank you, Mr. Chairman. And I know a lot of you have been worn out on this bill. Property assessors have been knocking on your doors, or at least their lobbyists. And I just want to tell you what this is about. And this amendment, I would have thought would take care of their concerns. And I don't know really whether it has or not, but it certainly was our intention in this amendment. It established that a clear statewide standard for timeshare properties in Tennessee are to be classified as residential property. Every other state in the union recognizes them as residential properties, unless an occupancy tax is being collected, in which case the appropriate commercial portion may be assessed accordingly. We've got court cases that even establish this. So this is a long-standing precedent. And what has been done previously by 2 counties out of the 95 counties is to say that certain timeshare properties, they just pick and choose, I guess, are now commercial. And so those owners of the timeshare properties don't even know that until they get an increased bill in their maintenance fees every month and wonder why that happened. And so this just clarifies in law what has been the practice for a long, long time, and that is to classify timeshare properties as residential. They're like a second home for a lot of people around this country. This approach is not a new policy. It's firmly grounded in existing state law, which provides that when a property is used for more than one purpose, it must be apportioned among classifications. The State Board of Equalization's rules direct that property assessors shall determine the share of market value attributable to each use and assess the property proportionally. This bill simply codifies and clarifies what's already been the law in Tennessee and been the practice, ensuring that it is applied consistently to timeshare properties just as it is for other mixed-use properties. I'll just give you a personal testimony. So I'm a timeshare owner. When we first looked at becoming a timeshare owner, the thing I learned from other owners is the biggest cost you're going to have long-term is the maintenance fees. What you pay on a yearly basis to maintain that property. That's insurance, the taxes, mowing the grass, the landscaping, keeping the pool up, whatever it might be. So I bought with that in mind, knowing that the tax rate was at a residential rate. I have a contract that was based on. And by what these two assessors have done over the last several years has changed the rules in the middle of the game for me. I'm now going to be paying, if they choose these particular properties that I own, I'm going to pay at a higher rate than I ever dreamed that I would. And there are people all over this country that are going to be affected by this law, what you do today, because there's thousands of owners across this country that own property in Tennessee in a timeshare. And so I ask you to consider this. I'd be glad to answer any questions, but I've got, the wording from the manual that property assessors use. It's really clear of what they're supposed to be doing. And we've had two that have kind of changed and gone a different direction. It's created a fiscal note. I'll deal with finance on that. But I just ask you to consider that property owners bought these knowing they're residential. And now someone's changing the rules in the middle of the game. And I just don't think that's the right thing to do. It's not right for those people that have these contracts.
Thank you, Mr. Sponsor. You've heard the explanation from the sponsor. We do have people signed up to speak, but I will take questions to the sponsor if you need to ask them at this time. Seeing none, without objection, we'll go out of session. And the first person I have on the list is Mr. Will Denami. Okay. Mr. Denami, before you start, I would like to recognize Representative Dixie.
Thank you, Mr. Chairman. I just would like to recognize our county trustee. She's standing up there back there. She just walked in, Miss Erica Gilmore. Thank you.
Okay, Mr. Denami, you will have 3 minutes. Give us your name and who you're with.
Thank you, Mr. Chairman and members of the committee. My name is Will Denami. I'm here on behalf of the assessors of property who ask you to vote no on this legislation. And I appreciate the chairman very much and the amendment that he's worked on to try to ease the concerns. It does not. This bill would overturn the law, and there's a court case from 2023, the Court of Appeals. There's two counties primarily this affects because that's where timeshares are. There was another timeshare property in Cumberland County. My understanding is it's not being used as a timeshare property anymore, but it was on commercial according to the assessor property. This latest amendment would have the assessor trying to review the property on an annual basis to determine whether or not it's been rented, and administratively that's not feasible. So we'd ask you not to change the law. This has been through the Court of Appeals in 2023, and I'd be happy to answer any questions.
You've heard the explanation of our guest. Is there any questions for the guest? Seeing none, thank you for being with us. Oh, Representative Butler.
Thank you, Mr. Chairman. So we're going to charge a commercial rate on a residential property is what the whole debate is. When you buy a timeshare, you are buying 1/52nd, essentially 1 week of that timeshare or whatever you want to buy, but it's still, you're buying a portion of a house. So it's no different than you're buying a portion of your primary residence, is it not?
Mr. Denami.
Thank you, Mr. Chairman. No, it's not. And so what the ALJ found was that the resort should be classified as commercial. The taxpayer and its affiliated business entities use the resort directly or indirectly for the commercial purpose of producing income by providing transient vacation accommodations to thousands of guests each year. So while you do have a reservation for that property, it is still being used for an income producing purposes. And according to the Constitution, income producing property shall be assessed commercially.
Representative Butler.
Thank you, Mr. Chairman. So resort may be making money and the resort properties may need to be subject to commercial property tax rates, but the individual house, I don't know that that's actually fair on the house itself where the person owns 1/52nd or 1/26th or whatever, however many weeks they've bought. The resort property and the residential property, are they not two different things?
Mr. Denami.
Thank you, Mr. Chairman. So they're an integrated entity. The trying to break it out on an individual case-by-case basis would be not feasible. The way this is done, and in this case, it's in front of us here, it was all integrated into one. So the central taxpayer was American Resort Development. So it's not to individual, if there's 52 people that own an individual unit, they're not all listed as a taxpayer. It's the one.
Okay. Thank you.
Representative Butler, okay. Chairman Moon?
Thank you, Mr. Chairman. Mr. Denami, this is commercial. Should they be paying hotel motel tax for each stay?
Mr. Denami?
Thank you, Mr. Chairman, and thank you for the question. What's important to recognize here is that Tennessee is different from all other states when it comes to taxation, especially property taxes. So the Constitution of Tennessee controls property taxes. Hotel motel taxes are going to be different, whether local jurisdictions have adopted those and have those in place. But yes, they will be liable for those nightly rentals for sales tax, local option tax, hotel motel tax.
Thank you,
in
Mr.
Tennessee.
Chairman.
Next on the list is Chairman Howell.
Thank you, Mr. Chairman. Mr. Denami, who actually pays the property tax when they pay the tax bill at the end of the year, like all of us homeowners do? Who actually pays that? Is it
Mr.
the individual?
Denami?
Right. Thank you, Mr. Chairman and members. In this case, it was American Resort Development.
So American Resort Development actually pays the property tax. Next question, if I may, Mr. Chairman.
Yes, sir.
So I hear advertisements all the time. There are cottage industries that have sprung up to try to help people get out of their timeshare contract because they've discovered what they say in their advertisements that they don't really own it. They just buy time. What would be your assessment of that?
Recognized.
Thank you, Mr. Chairman. I'd rather not try to opine on that if I may, if I can just stick to the property tax part.
Okay. Thank you, Mr. Chairman.
Representative Butler for a follow-up.
Thank you, Mr. Chairman. So in a condo association, who pays the property tax? If the condo's got 150 condo owners, does the condo association pay the property tax or does the individual pay the property tax?
Representative Denami.
Thank you, Mr. Chairman. Thank you for that question. So it's different. A condo would be deeded to an individual person, which they would pay the taxes, but there also could be an HOA assessment on the overall structure or the amenities, which then go to the HOA.
You're recognized.
Thank you, Mr. Chairman. So those amenities taxed as a commercial rate or a residential rate? In the
Mr.
HOA?
Denami.
They should be, well, it depends on how it's structured, it depends on what they're doing, but they could be commercial or they could be residential. It depends on what they're doing. So are they using them for income producing purposes? And that'll answer your question on all of them.
Anybody else have questions for our guest? Representative Dixie.
Sorry, Mr. Chairman, I just thought of it. As you said, it depends on the individual use. How could a property assessor determine the use or how it's being used throughout the year?
Mr. Denami.
Thank you, Mr. Chairman. And that's the central problem with this amendment is they would have to track each individual one each year and they couldn't realistically do that.
Any other questions for our guest? Thank you, Mr. Denami, for being with us, and we appreciate your testimony. I have a Addison Russell. Sir Addison Russell. Okay. Miss Russell. And there's also a Matt Russell. Will you please come on up too? Give us your name, who you're with, and you'll have 3 minutes.
Addison Russell. Thank you, Mr. Chairman. I'm here today on behalf of the American Resort Development Association. And we are proponents of the legislation and think that this is important for timeshare owners across the country. Just to clarify some things, as I said, American Resort Development Association is my client and they're the trade association. They are not a taxpayer. And so from my understanding of it, and I know Mr. Denami has testified and speaks on behalf of the assessors, but the Tennessee Timeshare Act does allow these bills for property tax assessments to come in one bill to make it easier on the assessors. And then what happens when the association gets that bill is that they send it out to all of their owners. So owners are getting assessed at a 1/52nd rate of the bill or a 2/52nd rate of the bill, depending on their interest. Chairman Todd has done a really good job presenting the bill. And as he said, we do think that it is necessary so that we don't have counties in Tennessee that are the only counties assessing these properties at commercial rates. Most owners do use them as their vacation home. They are not income producing for those owners. These people did not buy a timeshare thinking that it was going to be a commercial investment. We think that the amendment strikes at a really fair balance and is how other mixed-use properties are being treated. The lawsuit in question did find that that one property did have the developer had some unsold units that were being rented out. And so that kind of supported that holding. And that's why our amendment really seeks to match that court ruling, that if there are units that are unsold and being rented out by a developer, those can be assessed commercially. This language does match what the state of Missouri does, which is the only other state that doesn't have a 100% residential classification.
Any questions? Representative Martin.
Ms. Russell, is there anything in the law that would prohibit an owner of a timeshare from renting their week to their neighbor, their cousin?
Ms.
where it
Russell.
becomes an income producing?
Thank you, Mr. Chairman. There's nothing in law, but a lot of contracts, as Chairman Todd mentioned, he signed a contract. A lot of HOAs or contracts do not allow owners to rent out their interests. In fact, the lawsuit in question actually says that the owners of the property in question were contractually prohibited from renting their timeshare interest to third parties. The developer was able to rent out unsold units, and then also they were able to rent out deeded timeshare interests that were unoccupied. But the owners were contractually prohibited from renting out their interests.
Representative Martin.
But they're an owner of a timeshare, if they're whatever association that they're with, they could decide in their timeshare that if they wanted their clients, their owners, to rent it, that they could do that. That would be permissible, and there would be nothing against that in the law, correct?
Ms. Russell.
Thank you.
That's correct, Chairman. Much like any other HOA that may ban short-term rentals, the HOA can decide whether they want to allow that or not. Many HOAs do not allow that, and then many contracts that you sign with a developer will not allow for that.
Seeing no other questions for our guest, thank you for being with us today.
Thank
Matt,
you.
are you testifying? Okay. The last person on the list is Mayor Larry Waters. Mr. Waters, you'll give us your name, who you're with, and you'll have 3 minutes.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to be here today. I am Mayor Larry Waters, Mayor of Sevier County. And my discussion today comes on behalf of Sevier County and the cities of Sevierville, Pigeon Forge, Gatlinburg, and Pittman Center that are located within Sevier County. I come to you today in opposition to House Bill 889. Sevier County has classified timeshares in our county for several years due to the commercial nature of timeshares. The Tennessee Court of Appeals decision concerning 2 particular resorts held that timeshare resorts referenced in this case contained two or more rental units was therefore commercial according to the language in the state constitution. While timeshares may have a form of individual ownership in the means of points or weeks, their actual use, operation, and impact on Sevier County clearly align with commercial property and not residential. The fundamental question in this discussion should be, is a timeshare truly a residence or is it a commercial lodging business? When we look at how timeshares actually function, I think the answer is clear. Timeshares operate very similar to hotels and overnight rental properties. They are used for short-term stays. They are marketed to tourists. They are cleaned and prepared for guests, and they are operated by management companies as a part of a large hospitality operation. The units are not primary residences. In most cases, an owner may stay only in a unit for 1 week out of the year. Typically, the owner is not buying time in a specific unit. They are buying points or time that can be used at multiple resorts. People who exchange club points or own interests elsewhere to stay in Sevier County are still renters. Further, between January 1st and March 30th of this year, Sevier County Register of Deeds processed approximately 12,500 documents. Of these, 8,500 documents are from businesses and corporations to owners connected with timeshare. Pretty amazing, given timeshares make up less than 15% of our lodging offerings. Outside of use by people who are using points and allotted time, the property is used for transient occupancy, just like a hotel. I can go directly to a timeshare company website now and book a room, a villa, or a condo, just like VRBO or a hotel site. If it looks like a hotel, operates like a hotel, and competes with hotels, then it should be taxed like a hotel. Another issue is that we use public infrastructure on all of these timeshare units. Even valued at commercial, Sevier County, if you own a piece of commercial property valued at $30,000, you will pay around $178 in county property taxes. If you own $30,000 of points in it or time in a timeshare, you would pay around $25 a year. Timeshares are already receiving a discount in valuation because Sevier County values them as a $250,000 condo and not 50 owners at $30,000 for sale.
Mayor.
I'll conclude by saying this would cost the county about $1.1 million, and I'm certainly not disparaging timeshare. They provide jobs, they provide revenue for our county, and we're proud to have 16 of them in the county. My son worked for many years in the timeshare industry, so I'm very familiar with that. So having said all that, thank you, Mr. Chairman, for the opportunity.
No problem. Any questions for Mayor Waters? Representative Warner?
Yes.
Thank you, sir, and thank you, Mayor, for being here today. And you may have just answered my question there at the end of your statement. But let's say if I owned a cabin up in the Smoky Mountains or Pigeon Forward area, and I owned it myself and came 2 or 3 times a week and visited, would I fall under this tax?
Mayor Waters?
If you have a cabin that's on a short-term rental program, it is assessed commercial. But if it is a second home and you don't have it on a short-term rental program, you would pay on a residential.
Thank you, sir.
Chairman Rudd?
How long, I believe one of the two that testified said that there were only 2 counties, Cumberland and yours, that are taxing this. Well, how long have you been collecting this way on these units?
Mayor Waters?
I don't. It's either been 2 or 3 years. It was after the court case that the Court of Appeals ruled, and the state Supreme Court refused to hear the appeal, and we assessed it commercial after that case.
Chairman Rudd?
Oh, thank you. Do you know why that only 2 states tax this way in the nation, and any background on that?
Mayor Waters?
I don't. Other than the fact that I think we've looked at it and determined that these are commercial entities and not residential.
All right. We have Representative Powers, and he would like to ask legal a question. So without objection, we'll go out of session to hear from legal. Mr. Powers, you're recognized.
Thank you, Mr. Chairman. Yeah, there's been several references today to the constitutionality of this. So I just wanted to go out and ask legal what their opinion was on the Tennessee Constitution and how it affects this.
Thank you, Matt Mundy from Legal. I'm going to start with the constitutional provision, but I'm just going to say generally that I think that the manner in which this may apply and the nature of the property, how many units it has, whether there's common areas, things like that could impact the way that it's taxed. Article 2, Section 28 says residential property is to be assessed at 25% of its value, provided that residential property containing 2 or more rental units is hereby defined as industrial and commercial property. And the commercial property rate is 40%, so a margin of 15%. Timeshares come in a number of different forms. You can have communities with single-family residences that are individual, and there's an association that governs that. I think timeshares are shared interests in property, and I think that I'm familiar with the 23 case. I think this, the particular nature of the property that's being described in this amendment is distinguished from the property in that case. And if you look at this description, it's revising the definition of residential property. But for these particular vacation club not rental properties, excuse me, these timeshare and vacation club properties, you have to actually have an interest in the real property. So you are a property owner along with others. And it says there's an exception that it doesn't apply to units that are actually rented and subject to an occupancy tax. So if you're using this type of property as a Airbnb or a short-term rental, or it would be subject to a hotel motel tax, this definitional change does not capture that. It is someone who has an ownership interest in the property and that they're not renting it. Now, someone could certainly, there could be almost like a condominium complex that's used as a timeshare property, but that would be taxed as a commercial property if it's being rented out.
Okay.
Chairman Powers.
Thank you. No, thank you, Mr. Chairman.
Chairman Rudd, you have a question for legal? Go ahead, sir.
Is the, what you'd mentioned, and again, I'm asked and I don't know, in 2 or more rental units, it's not the actual structure, it's the owner, isn't it? Because you could have 6 or 8 people in, say, a condo or something, and one person lives in one unit and owns 3 others. The term is the structures tax. It's the individual owner, isn't it, of the rental property?
Legal.
Chairman Rudd, I have not considered that, but I will read the language of the Constitution. It says, provided that the residential property containing 2 or more rental units is hereby defined as industrial and commercial property. So if that parcel of property, I suppose, contains 2 or more rental units, then it would be considered commercial. But there's 2 prongs there. There's the fact that it's a parcel of residential property that contains 2 or more rental units.
Chairman Rudd for follow-up.
Well, thank you, Mr. Chairman. I think that's what I was getting at, because if you have a complex, whether it be 3 or 10, that if the owner of several rental properties in that building also lives there, his particular residence is taxed at a residential rate. It would be the rental units taxed at a commercial rate, if that's not how I understand the law and it's been implemented.
Legal.
I have not considered that scenario, but I assume that's the case. Yes, that the person, their primary residence is going to be taxed at a residential rate. And if he's got rental properties on his property, they'd be taxed at a commercial rate. And I'm not sure how the tax assessors would make that calculation.
Mr. Chairman.
Follow up.
I think that that's the way it's been implemented and understood. It's same kind of like a duplex. If the owner lives on one side but rents the other, his side is a residential rate, but the other side's a commercial rate. And these timeshares, if you're using it as a second residence and you're not renting it out, you should be at a residential rate. But if some of the owners in there rent their unit out during their period, then that's a commercial rate. So it seems like it would be, to be fair, if the actual owner is not renting it out, that his should be taxed at a residential rate.
Thank you. And I agree with you. And I presume that the assessors have a mechanism for taxing that property appropriately under those circumstances.
All right. Any other questions for legal? Seeing none, we'll go back in session. And any questions for Mayor Waters? Seeing none. Representative Todd, thank you for being with us today, Mayor Waters. Appreciate your testimony. Representative Todd, you're recognized.
Thank you, Mr. Chairman, and I appreciate the indulgence of the committee and to dig into this because it does affect thousands of people. It really does. The court case that was mentioned, again, that decision was for one specific property, one specific case, and it even says that at the end of that ruling. It does not apply to all, and they even agreed, I think, with the amendment that I have on. If it's partially commercial, then charge that part commercial. If somebody's renting it out, like in the situation that Ms. Russell mentioned, where the developer still had a chunk of the property, they just hadn't sold yet, and yet they're renting it out like a hotel, then they ought to be paying occupancy tax, and that should be commercial. And that's what the amendment does. It clarifies that. And I firmly agree with that. That's not how we started this bill, but as we progressed and heard the concerns, we brought this as a compromise that I think is very reasonable, that if you're getting occupancy tax off of it, it ought to be commercial. And that goes to some of the questions the members have even asked here. So I would appreciate your consideration of that. That is a very significant part of what the debate is. And again, the contractual obligation. When I bought the timeshares that I have, I knew it had an HOA that pays the taxes. The association, by the way, does not pay the taxes. That's an association of a lot of timeshare owners and developers. So they don't pay taxes per se. But each one of these properties has an HOA. They're literally member owners that sit on that HOA. I could run for that office if I wanted to. I choose not to. I'm a little bit busy up here. And I've been a member of an HOA one time, and I'll never want to do that again. So as far as a leader or an officer of an HOA. But the HOA runs everything. They have annual meetings. They present the budget. They budget out what the maintenance is going to be, what the taxes are going to be, and they reassess our maintenance fees based on that, of all those factors. And so we as owners, when we go and stay in those properties, we take care of them. We make sure if we allow a guest, so I have guests sometimes that I allow, like I had my son and daughter-in-law stay in a property just weeks ago because they wanted to get away for a weekend for a meeting they had in Atlanta. And so I know who's staying in that unit that is in my name, and they take care of it. So I know those maintenance fees are going to stay low if it's people that are going to be taken care of. They have a vested interest in taking care of the property. So the amendment, I think, makes it very clear. If you get an occupancy tax, if it's being rented out, it should be taxed at commercial, that portion. And the manual and the court case even indicate that portion be taxed commercially. And the assessors already have mechanisms for doing this. That's another question that came up. They have that mechanism and can make that distinction between the two rates.
Representative Butler.
Thank you, Mr. Chairman. I think there's a distinct difference between a hotel and a timeshare. If I'm not mistaken, Chairman Todd, when you buy a timeshare, you get a deed. Is that not correct? I believe Mr. Waters even said that they issued deeds for those particular properties. Is that not correct?
Chairman Todd?
I have a deed for every single timeshare that we own. We own several that accumulate to what our usage is per year.
Representative Butler.
Thank you, Mr. Chairman. So when you go stay in a hotel, you do not get a deed when you stay in that hotel. If you go stay in an Airbnb, you do not get a deed to the Airbnb. But when you buy a timeshare, you get a deed. I think that is a very distinct difference in what a residential rate is and a commercial rate is, and whether you pay an occupancy tax or whether you don't pay an occupancy tax. So if I own a deed to my home, I'm not paying an occupancy tax to be in my home. I own it, just like you own a timeshare. I think it's unfair to charge somebody a commercial rate for something they own. Now, I agree with you when you said if they are renting their timeshare, then you would pay an occupancy tax or whatever the case may be, and then potentially a commercial rate. And Ms. Addison testified that there are restrictions on renting out if there is a timeshare association that sells those timeshares and restricts those from being rented by owners, then I think it's very distinct that it should be at a residential rate. And with that, Mr. Chairman, I'll stop.
Representative Carringer.
Thank you, Chairman. And I guess I've got some questions and then just some statements. I mean, so when you do timeshare, you normally do like a week or 2 weeks or whatever, and you have to use those same weeks every year. You can swap out with someone if they agree to swap your week out. But we had some friends that owned years ago, and they bought in Fairfield when it first was starting up, and they really got a really good deal, I would say. But they could travel all over the U.S., even out of the country, and swap out their week that they had bought in Fairfield. So they were investing because I guess they were paying a little bit, each month and all, to where they weren't just paying out one lump sum when they went somewhere and traveled. So my other thing is, if timeshares, it's kind of like sort of like renting, but you're not, because you're paying every month something, to keep it up and all that. But isn't it hard to prove because we know people that own, and they have sold their weeks out to friends and all to go other places and all. So is it not hard to prove who's renting theirs out as far as it being used commercial? I mean, how does the property assessor really determine that? Because they'd have to just be driving by and ask somebody. How could property assessors really prove that you're making money off of it, that you're not staying there? Is that a question? I don't know who that's a question, because I can see both sides on this. But there's also kind of a proof there. How do you prove it? So.
Next on the list is
Can't read that.
Eldridge. Who wants to respond? He didn't. Who wants to respond? Okay, I gotta see your hand. You're recognized.
Thank you, Mr. Chairman. I raised it, and I think Mr. Butler was right in front of my hand with your vision, so
Okay.
I appreciate that. And just to respond to that, as has been stated, you get a deed, so it's not, you're not renting. Now, granted, just like the deed on your house, you've got a deed, but you also have to mow the yard. If you don't have a lawnmower, you got to pay somebody. So, or if you're not there, second home, same thing. You're paying for somebody to mow the grass, to paint, whatever the maintenance is on it. You're paying the insurance on it, even though you're not there every week. You're only there, a few times a year. And then when you leave, you pay somebody to come in and clean it and have it ready for the next time. So it's not any different. As an owner, that's what I do. I book the resort, a certain kind of room, depending on whether it's my whole family or just me. And I know it's ready when I get there. Somebody else stayed there last night because they have an ownership as well. And so I'm able, there are fixed weeks. You referred to a fixed week contract, and for 50 years, those have been around. That didn't appeal to me. But the particular timeshare we bought into, the developer did a point system. So each deed comes with a certain number of points, and based on your level of purchase, you're purchasing more points for that resort. And that will get you a certain amount of days or nights, sometimes based on weeks, sometimes. And so that was interesting to me because, again, I don't stay in Atlanta hardly ever, but like my son wanted to, I booked that for him and his wife that used my points that I have from all the deeds that I have. They stayed there, they check out, somebody else stays there the next night. I do that when I'm in Nashville. That's how I live here for 4 months I use my timeshare points at the properties here in Nashville. So it's very convenient as a second home. And I think everything that's been said pretty much points to that. Now, again, are there situations where a developer is going to have ownership still in things he hasn't sold yet and wants to rent those out? I have heard of those being on hotels.com and other things. That very likely happens. I've heard of that happening, and I think it does. And those assessors can find that. They can see that. Those advertisements are out there very easily. You just search that property name and boom, you're going to see whether they're renting it out or not. And you need to be charging them an occupancy tax and then charge them for the commercial rate on those units, however many units that is for that particular condo. And that's what this amendment does. It fixes that concern over what we originally filed. It takes care of that. If there's an occupancy tax, then certainly it ought to be commercial for that portion of the property that is being used commercially.
Next on the list is Representative Eldridge.
Thank you, Mr. Chairman. To move previous question.
Previous question has been called. We're ready to vote on House Bill 889. Moving on to, hang on just a second, Finance, Ways and Means. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, you'll close the board and announce the vote.
Mr. Chairman, you have 7 ayes, 12 noes, and 2 present not voting.
Bill fails. Okay, we're going to 890. This is item 22. All right. House Bill 890. Have a motion and do I need a second? Motion and a second. I do see we have amendments. Would you like to give us your drafting code?
I have 16686, sir.
That is correct. Do you want us to place that on the bill for discussion?
Yes, please.
Without objection, we're placing amendment number 16686 onto House Bill 890. Need a motion on the, thank you. Motion and second on the amendment. Without objection, we're placing 16686 onto House Bill 890. All those in favor, please say aye. Those opposed, no. Your bill's now amended. You're recognized, Chairman.
Thank you, Mr. Chairman. This bill makes it clear that municipalities do not have the authority under state law to forgive county taxes, and it has 2 takeaways from it. If a corporation negotiates payments in lieu of taxes that result in a proposed agreement that could result in the abatement, reduction, or non-payment of taxes, the corporation shall not enter into any agreement until the governing bodies of both city and county approve the terms of the agreement by adopting a resolution at a public meeting. Any agreement that affects city and county revenues prior to gaining the approval of both governing bodies shall be considered void. This amendment clears up an issue that would ensure both cities and counties utilize the same criteria when approving the terms of an agreement by having the corporation provide written notice of the agreement to the chief executive officer of each taxing jurisdiction. I was quite surprised to find that we've had some cities literally abating the taxes for not only their municipality, but also the county they reside in, and the county had no knowledge of it, and this fixes that.
You've heard the explanation, the sponsor. Any questions? Seeing none, we're ready to vote on House Bill 0890, going on to calendar and rules. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 21 ayes and 1 no.
Bill moves on to calendar and rules. Next item we have is item number 23, House Bill 2069 by Chairman Todd. Got a proper motion and a second. I do see we have some amendments. Which amendment would you like to go with, sir?
Drafting code 15628.
That is correct. I need a motion. Motion and a second on the amendment. Without objection, we'll place amendment 15628 on to House Bill 2069. All those in favor, please say aye. Opposed, no. Your bill's now amended. If you'd like to be recorded as a no, see the clerk. You're recognized, sir.
Thank you, Mr. Chairman. House Bill 2069 addresses 2 connected issues: the expansion of public nuisance lawsuits and the growing practice of municipalities hiring private trial lawyers on contingency. That's key word, contingency, to bring these cases. In recent years, municipalities across the country have used broad public nuisance theories to sue over issues with statewide or national implications, allowing local governments and profit-motivated attorneys to effectively drive policy through the courts. This bill restores guardrails by requiring the Attorney General to review contingency fee litigation contracts before a political subdivision can hire outside lawyers to pursue these cases. It also clarifies that the public nuisance should only apply to traditional interference with public rights to land, preventing the theory from being expanded to broad policy disputes. Importantly, the bill does not affect existing consumer protection, product liability, or other legal remedies available under Tennessee law. Ultimately, it ensures the major policy questions impacting all Tennesseans are decided by elected lawmakers or the Attorney General, not through municipal litigation. It does not prohibit a municipality from hiring an attorney for any purpose whatsoever on an hourly basis. This is just stopping the practice many attorneys have had of going and handing out flyers to see who will grab a lawsuit and sue folks over some frivolous things, get a big settlement, and cash in over nuisance claims. And that's what this is attempting to fix.
You've heard the explanation of the sponsor. Any questions for the sponsor? Representative Mitchell.
Thank you, Mr. Chairman. Do you consider the opioid addiction crisis in our state and in the country a nuisance?
Chairman Todd.
I consider that a national problem and certainly for our purposes here, a state problem, not an individually local problem. And that's one of the things that has been mentioned in this is that, if a particular city or county wanted to sue over this, this is actually a state issue that's already being dealt with. And that's why we involved the Attorney General. I think that was a very good move to put that in this legislation to make sure that when the Attorney General sees that, oh, there could be a statewide application here. We've got multiple cities, multiple counties, then they can fight that instead of having 95 or more attorneys deal with it across the state.
Representative Mitchell.
Well, I'd say Madison County might disagree with you. Let's see, they've probably in 23, they had 363,000 reasons to disagree with you. 24, they had 364,000 different reasons to disagree with you. 25, 290,000 reasons to disagree with you. And it just continues on. They're getting, $200 or more $1,000 for the next several years, as is all counties in Tennessee. If you for the members of the committee, just search Tennessee Opioid Abatement Council, and you can see just what your county would not be getting if he would have passed this 4 or 5 years ago. This is we're going to put it in the hands of one individual and allow the Attorney General of this state to decide what the policy is for all of these counties and cities. And I think, all politics is local. So why would you think that the Attorney General knows what's best for Kingsport, Memphis, Gleason, Greenfield, whatever town in this state, more than the local people in those communities who are dealing with problems and issues on a daily basis?
Chairman Todd.
Thank you, Mr. Chairman. And out of those 300 and something thousand, multiple times you mentioned that from Madison County, they have my phone number and they've not called me saying this is a concern because they didn't file that lawsuit. That lawsuit was filed by the Attorney General, and they're the ones that are gathering that money. And every year we come back and add more companies to that are involved in that lawsuit. And that's what's bringing this money down. So it is a local issue, but more importantly, it is a state issue. Every single municipality you mentioned, everyone you referred to, is a subdivision of state government. So the state has the sovereignty here, has the authority. This just keeps it where the Attorney General can decide, okay, this is just strictly a Madison County issue. You go do your thing. That's still available here. But if it's a statewide application where multiple counties and cities are involved, then the AG would take over.
Representative Mitchell for a follow-up.
Yeah, one, I bet they cash the check each year. And two, I don't think, the size of that lawsuit, there's a law firm, a couple of blocks from here that was part of the national lawsuit, one of the first that won the first initial opioid settlement. And it's been very beneficial for all of these counties and cities in this state. And I don't think the staff of the Attorney General's office could have handled the size of that lawsuit in any form or fashion.
Representative Dixie.
Thank you, Mr. Chairman. I just kind of wanted to make a couple of comments and then I have a question. Is that I think that through the course of this General Assembly, we've seen a lot of legislation that restricts people's ability to bring cause if they feel like they were harmed. And now we're going to put this in the hands of the Attorney General. And the Attorney General has kind of used it. It's become more political. Instead of being the attorney for the entire state of Tennessee, he has leaned toward one party more than the other. So I don't feel comfortable having him make these decisions. Now, you yourself said these nuisance lawsuits have resulted in millions of dollars in damages. So that means that a jury or a judge or both found that someone was harmed in that. So apparently there's value that's going on in it. So what would be the definition of a nuisance lawsuit, and who would be the determining official to say that this is a nuisance lawsuit, or have they been defined? How do we determine that?
Chairman Todd.
Well, first of all, I didn't make the statement that there have been millions of dollars and all of that. That wasn't part of what I've presented here today. There have been abuses of the system, I believe, and that's what this attempts to fix. And all the money that's been mentioned to go into the cities and counties now has come from lawsuits that the Attorney General fought for. That's who negotiated those deals. That's who has gotten that money for my county and yours. And this clarifies that the ancient common law concept of public nuisance cannot be manipulated or misused to attempt to regulate industries and advance social and policy priorities in the courtroom. That's all it does.
Representative Dixie.
Just point of clarification. The lawsuits were brought by private attorneys, not the Attorney General to begin with. And when you spoke earlier, maybe you said it erroneously, but you did say they brought damages. But I think that this is an opportunity for us. We're restricting people's right to bring cause of action when they feel like they've been harmed. But again, my initial question was, how do we define what a nuisance lawsuit is?
Chairman Todd.
I don't have that definition in front of me. I'm sure legal could give you that. But I do know that this does not restrict those municipalities or counties from going after anybody they want to go after. This strictly says you can't do it with a contingency basis where a lawyer is going to make a percentage of what the win is. That's what many of them are going after, is let me get a big settlement and make my B&W payment. That's what they're going after. And this stops that. This says, no, you can still be hired by the hour to do whatever that city or county wants you to. You just can't do it on a contingency basis. That's all this deals with.
Mr. Chairman, could we go out of session and legal and ask is there a legal definition for nuisance?
King, without objection, we'll go out of session to hear from legal. Legal, you're recognized.
Thank you, Matt Mundy from Legal. There's actually nuisance law in the common law. It's bifurcated. There's private nuisance and then there's a public nuisance. So private nuisance would be something like your neighbor burning a pile of trash and the smoke blowing over in your yard and, being a health hazard and causing you to cough or something like that. It's a tort action. So it involves negligence on the part of someone. A public nuisance would be a civil tort involving interference with your rights that are common to the public generally. Something like that may be a widespread health or safety issue. It could be blocking a public right-of-way. It's a fairly broad cause of action that just interferes with property rights, whether it's private or public.
Is that good? Without objection, we'll go back in session. Next on the list is Chairman Powers.
Thank you, Mr. Chairman. I move previous question.
Previous question's been called. We're ready to vote on House Bill 2069. Moving on to calendar and rules. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, you will close the board, announce the vote.
Mr. Chairman, you have 15 ayes, 5 noes, and 1 present not voting.
Bill moves on to calendar and rules.
Thank you, Mr. Chairman and committee.
We're going to item number 7, Dr. Love. House Bill 427 by Representative Love. Proper motion and second.
Thank you, Mr. Chairman and members. This particular bill you all heard before is about giving state employees the opportunity to have some weeks off for leave after they give an organ. We put the wrong amendment on last time, and so we're back here, Mr. Chairman, to put the right one on.
Okay, give us that drafting code.
That drafting code is 012136.
That is correct. Without objection. That's the amendment we adopted last time, according to research.
We adopted 2 last time,
That's the second one.
so this is the correct one.
It makes the bill. We're checking, hang on. The bill.
Okay, so the right one is on.
Yep.
Okay, and the wrong one is off.
There was 2 adopted, 06197 and a 12136. The second one rewrote the bill, so your first one's not in order.
Correct. I want the, okay, thank you.
All right.
So this is the correct amendment going forward.
The correct amendment is traveling with the bill. And any questions for the sponsor? Representative Powell?
Thank you. Is this the first time you've repassed a bill?
This is the first time, yes. It's been a wonderful experience. I really like this committee, and I'd love to see it again on another bill, though.
Okay. All right. Any questions for the sponsor? Seeing none, we're ready to vote on House Bill 427, moving on to calendar and rules. All those in favor, please say aye. No, we got to vote on it. Sorry. I tried to help you, Dr. Love. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 20 ayes and 0 noes.
Bill moves on to calendar and rules.
Thank you, Mr. Chairman and committee members.
You got one more bill here. It is House Bill 0674.
Yes, sir. And
Got a proper motion and second. I do see it has an amendment. Please give us that drafting code.
013018.
That is correct. Without objection, we've got a proper motion in second. We will place 13018 onto House Bill 674. All those in favor, please say aye. Opposed, no. Your bill is now amended. You're recognized.
Thank you, Mr. Chairman, and I do want to acknowledge that I've been working with Department of Correction on this particular piece of legislation. This is going to create a study from the department to really look at the cost of family members having to travel to see other family members who are incarcerated and to identify where there are gaps in maybe moving persons closer to home. And it's just a study that will be conducted by the Department of Corrections. And with that, Mr. Chairman, I would ask for passage.
All right. You've heard the explanation of the sponsor. Are there any questions for the sponsor? Representative Dixie.
Hey, Representative Love, I appreciate you bringing this. I have several prisons in my district. And if I get 10 calls, 7 of them are from family members with incarcerated family members. And this would help out a lot because they are saying, can we get them closer to here? A lot of times they have aging parents and just transportation is just an issue. So thank you for being thoughtful, and hopefully this study becomes, we can put it into law and they can put it into practice. But thank you very much.
Yes, sir. Thank you.
Any other questions for the sponsor? Seeing none, we're ready to vote on House Bill 674, moving on to calendar and rules. All those in favor, please vote yes on the board. Opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 20 ayes and 0 noes.
Bill moves on to calendar and rules.
Thank you, Mr. Chairman, committee members.
Going to item 33. This is House Bill 2314 by Representative Fritz. Proper motion and second. Representative Fritz, I see it has an amendment. Please give us your drafting code.
Thank you, Mr. Chairman. That would be 15641.
That is correct. Without objection, we'll place amendment 15641. We got House Bill 2314. All those in favor, please say aye. Opposed, no. Bill's now amended. You're recognized on your bill.
Thank you, Mr. Chairman and committee. The bill does two basic things, members. First, it places a statement, a posting rather, with the statement, attention, by engaging in this type of entertainment, you may be contributing to an increase in domestic assault, rape, sexual assault, and human trafficking. And that's going to be on entertainment establishments where pornographic type venues are held, nude dancing and so forth. And secondly, and this was part of what the amendment does, there were some concerns about the previous wording on the original draft of the bill. We changed that to a posting that says, for your information, production of these materials may contribute to an increase in domestic assault, rape, or sexual assault and human trafficking. And those words would be placed where pornographic and sexually explicit materials are sold and rented. Friends, I would offer you that human trafficking is one of the large problems that we need to deal with in these United States and in Tennessee. I would offer just a few words for brevity of some of the research that we found on this. Human trafficking is one of the most brutal and organized criminal enterprises operating today, both globally and here in Tennessee. This comes from a statement from an advocate back in my district. The International Labor Organization estimates that it's a $236 billion a year industry, exploiting approximately 27.6 million people, including nearly 2 million children. The Department of Health and Human Services has identified it as the fastest growing criminal industry in the entire world. A couple notes from the report from the University of Pennsylvania Sexual Exploitation Industry Research Finding Summaries compiled by Dr. Mary Ann Layden, Director of Sexual Trauma and Psychopathology Program at the Center for Cognitive Development. She offers these few statements, and I have quite an extensive document here. I'm just going to read a couple things. That disassociation abuse among multiple disorder patients, prostitutes, and exotic dancers, again, part of what this bill addresses. The strippers were reporting a rate of 65% sexual abuse, depression at 60%, substance abuse at 40%. The report goes on to outline all of the correlation, if not causation, of these industries to both sexual assault, rape, and human trafficking. And in closing with my comments, and I'll take certainly any questions you all have, this seems to be a reasonable and prudent way to identify these hazards to the public. We do this on packages of cigarettes. 16 Code of Federal Regulation 501, the Truth in Fur Labeling Act, protects animals by posting on garments where the fur is harvested. 16 Code of Federal Regulation 1501 identifies balloons, books, clothing, modeling clay, paints, and other small parts as possible choking hazards for children. We have labeling on our food for peanut allergies. I would offer you that this is not a new concept, but this is something that Tennessee can lead the nation in putting these postings on these businesses so that those people who participate in those establishments at least have a warning of what their actions may be incurring. And with that, Mr. Chairman, I'll stop and answer any questions after your favorable consideration.
Thank you very much. You've heard the explanation of the sponsor. Are there any questions? Representative Bricken.
Thank you, Mr. Chairman, and I certainly appreciate the legislation. The question I have, I'm certainly not sure a sign's going to change human behavior, but who enforces this? And if they don't post a sign, what are the fines?
Representative Fritz.
Thank you, Mr. Chairman. The legislation basically places the requirement of the sign on putting on giving the license for the first establishment. In section 1G, it says the board, this is the board that issues license to the exotic entertainment, shall not issue license unless the applicant certifies that a sign no smaller than 8.5 inches by 11 inches is posted at each entrance to the establishment. And then in the second case, Representative, if an adult-oriented establishment lawfully offers for sale, loan, or use sexually oriented materials, including print, video, and other media, then the board shall not issue a license to the establishment unless the applicant certifies that signs are posted at each display of sexually oriented material. So it's all about the display of the sign, sir.
Representative Miller.
Thank you, Mr. Chairman. If I'm reading the correct amendment, it says by engaging in any type of entertainment, you may be contributing to an increase in domestic assault, rape, or sexual assault, human trafficking. Why could we not include, if you notice any of these activities, you may contact your local law enforcement to complete that.
Representative
which will
Fritz.
give it more.
You're recognized.
Thank you, Mr. Chairman. I think we passed something along those same lines last year, Representative, that allowed for that type posting. I'm not certain of what the exact reporting was, but this takes on just a warning for the potential customer.
Correct.
Any other questions for the sponsor? Seeing none, we're ready to vote on House Bill 2314, moving on to calendar and rules. All those in favor, please say aye. Please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 19 ayes and 2 noes.
Bill moves on to calendar and rules.
Thank you, Chairman and committee.
Mr. Vaughn, Chairman Vaughn. Going to item 19. Item 19. This is House Bill 2386 by Chairman Vaughn. I do need a motion. Proper motion in second. I do see we have an amendment. Can you please give us your drafting code?
Yes, sir. That's Amendment 16385.
All right, got a proper motion and second on the amendment. Without objection, we'll place Amendment 16385 on to House Bill 2386. All those in favor, please say aye. Opposed, no. Bill is amended. You're recognized on your amended bill.
Thank you, Mr. Chairman. This bill deals with what happens when a municipality or political subdivision wants infrastructure upsized beyond what a development itself requires. There's a principle in land development, and this is my $50 word for the week, nexus of proportionality. Let that sink in just a little bit. Nexus of proportionality, which means that you can't require somebody to build an offsite improvement. It's not what's on their property, but an offsite improvement larger than what they need, But what this does is this allows the municipality and the developer to come together for a cost-sharing agreement.
You've heard the explanation of the sponsor. Are there any questions for the sponsor? Representative Mitchell.
Question on the bill.
Question's been called. We're ready to vote on House Bill 2386. Moving on to Finance, Ways and Means. All those in favor, please vote yes on the board. Opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, announce the vote.
Mr. Chairman, you have 19 ayes and 3 noes.
Bill moves on to Finance, Ways and Means.
Thank you, Mr. Chairman and committee.
Do you have any more?
No, sir.
Okay, all right.
I appreciate it.
All right, let's get Representative, I don't see him in here right now. Let's see, what's 61? Okay, we'll go ahead and take up item 61. Item 61. This is House Bill 2160 by Representative Butler. Got a proper motion and second. Representative Butler, please give us your drafting code on your amendment.
Thank you, Mr. Chairman. It is 014887.
That is correct. Got a proper motion and second on the amendment. Without objection, we'll place 14887 on to House Bill 2160. All those in favor, please say aye.
Aye.
Opposed, no. Bill's now amended. You're recognized.
Thank you, Mr. Chairman. This bill simply allows for the county commission, the legislative body, to terminate or discharge the county director of accounting and budgets in counties with populations from 22,500 to 22,600, according to the 2020 census. With that, Mr. Chairman, I'll be glad to answer any questions and move previous question.
Explanation of the sponsor, who is totally out of order. Is there any questions? Representative Warner.
Thank you, Mr. Chairman, and thank you, sponsor. Why the limit? What the population limit there?
Representative Butler.
Thank you, Mr. Chairman. So this was brought to me by my county commission requesting this, and according to legal, this has to change the 57, the implementation of the 57 code. So that's why it was drafted this way, to get them what they wanted and specifically tailor it to that county. To answer your question.
Representative Warner.
Thank you, sir.
Any other questions for the sponsor? Seeing none, we're ready to vote on House Bill 2160. Moving on to calendar and rules. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board and announce the vote.
Mr. Chairman, you have 22 ayes and 1 present not voting.
Bill moves on to calendar and rules.
Thank you, Mr. Chairman and committee.
Item number 2. Item number 2. This is House Bill 1839 by Chairman Hastings. Chairman Hastings, I don't see an amendment. You're recognized on your bill, sir.
Thank you. I'll give you a brief description of the issue quickly. Inmates who are excelling in local work release reentry programs are occasionally removed from these local jail work programs when pulled into state custody. What this bill does is simply allows local jails to keep state inmates that are successfully involved in work programs by first prioritizing the return of state inmates who are not enrolled in a work reentry program. With that, I'll be glad to answer any questions.
You've heard the explanation of the sponsor. Are there any questions for the sponsor? Seeing none, we're ready to vote on House Bill 1839. Moving on to calendar rules. All those in favor, please vote yes on the board. Opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 23 ayes and 0 noes.
Bill moves on to calendar and rules. Next item is item number 3. This is House Bill 2654. We've got a proper motion and a second. I do see we have an amendment. Can you please give us your drafting code?
16257.
That is correct. Got a proper motion and second on the amendment. Without objection, we'll place Amendment 16257 on to House Bill 2654. All those in favor, please say aye. Opposed, no. Bill's now amended. You're recognized on your amended bill.
Thank you, Mr. Chairman. This came via a resolution from the town of Sardis, deletes some obsolete provisions, replaces them with such things as salary of the mayor and aldermen shall not be altered prior to the end of a term, and the mayor shall not be permitted to cast a vote except in the case of a tie. With that, I'll be glad to answer any questions.
Any questions for the sponsor? You've heard the explanation. Seeing none, we're ready to vote on House Bill 2654. Moving on to calendar and rules. All those in favor, please vote yes on the board. Those opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 23 ayes and 0 noes.
Bill moves on to calendar and rules.
Thank you, Mr. Chairman. Committee.
We're going to item number 10. Item number 10. This is House Bill 2521 by Chairman Vidal. We've got a proper motion and second. I do see we have an amendment. Can you please give us your drafting code?
Thank you, Mr. Chairman. 13483.
That is correct. Got a proper motion and second on the amendment. Without objection, we'll place Amendment 13483 on to House Bill 2512. All those in favor, please say aye. Opposed, no. Your bill's now amended. You're recognized.
Thank you, Chairman, committee members. This legislation simply aims to resolve all outstanding statutory issues raised by the FBI regarding firefighter background checks. The FBI requires specific statutory language to approve state-level, multi-state, fingerprint-based background checks. Currently, the FBI, the Fire Service Coalition, and various firefighter groups across the state have developed specific language for finally meeting the FBI's protocol standards. These are third-party vendors, which use the department to run checks through private third-party providers, and then also TBI through state checks. The department may choose to continue using the TBI for state-level background. And with that, I am open to questions.
You've heard the explanation of the sponsor. Are there any questions for the sponsor? Seeing none, we're ready to vote on House Bill 2521. Moving on to calendar and rules. All those in favor, please vote yes on the board. Opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 23 ayes and 0 noes.
Bill moves on to calendar and rules.
Thank you.
Okay, we're going to item 77. Must be another book. Give us just a second to go to the second book here. Okay. This is House Bill 1514 by Chairman McCalman. Do I have a motion? Proper motion and second. I do see it has an amendment. Please give us your drafting code.
Thank you, Mr. Chairman. I have drafting code 012981.
That is correct. Got a proper motion and second on the amendment. Would you like us to place it on the bill for discussion?
Yes, please, Mr. Chairman.
Without objection, we're placing Amendment 12981 on to House Bill 1514. All those in favor, please say aye.
Aye.
Opposed, no. You're recognized on your amended bill.
Thank you, Mr. Chairman. Members, what House Bill 1514 does is simply say that a municipality cannot find a retail store in the event that a grocery cart is taken off of their property and picked up by the municipality 3 blocks down the road. They can't take any punitive action against them, as it was not the retailer's fault that that cart was indeed taken off their property. And with that, I stand ready for any questions.
You've heard the explanation of the sponsor. Anyone have any questions on the grocery cart stealing? All right, we're ready to vote on
Riveting
House Bill
stuff, Mr. Chairman.
1514. Moving on to Finance, Ways and Means. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Oh, wow. Does any member wish to change their vote? Madam Clerk, close the board and announce the vote.
Mr. Chairman, you have 23 ayes and 0 noes.
Bill moves on to Finance, Ways and Means. Next item, 78, House Bill 1696 by Chairman McCalman. Got a proper motion and second. I do see we have some amendments. Please give us the drafting code you'd like to run.
Yes, sir, Mr. Chairman. I have drafting code 016041.
Got a proper motion and second on the amendment. Without objection, we'll place Amendment 16041 on to House Bill 1696, moving on to calendar and rules. All those in favor, please say aye. Aye. Opposed, no. Your bill is now amended. If you'd like to be recorded as a no, please see the clerk. You're recognized, sir.
Thank you, Mr. Chairman. This is a much more impactful bill than a grocery cart one. But essentially what House Bill 1696 does is decrease the amount of time that the executive branch departments have to reimburse for their contracts. It goes down from 45 days to 30 days. It also requires a report to be provided to the General Assembly for any late payments that have been made to show how much interest is being spent at the taxpayers' expense for not paying our bills on time. And with that, I stand ready for any questions.
You've heard the explanation of the sponsor. Are there any questions? Seeing none, we're ready to vote on House Bill 1696. Moving on to calendar and rules. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board and announce the vote.
Mr. Chairman, you have 22 ayes and 0 noes.
Bill moves on to calendar and rules. Item number 79, House Bill 1697 by Chairman McCalman. Do I have a motion? Got a proper motion and second. I do not see any amendments, so you are recognized, Chairman, on your bill.
Thank you, Mr. Chairman. Members, what House Bill 1697 does is allow for the county executive or the municipal mayors to have a half-mast for a prominent citizen who has passed away. Currently, it's only the governor and the president of the United States who can issue half-mast. And with that, I stand ready for any questions.
You've heard the explanation of the sponsor. Any questions for the sponsor? Seeing none. Representative Martin, you are recognized.
Sponsor, I appreciate what you're doing here. My question is, like, when the flag flies at half-mast, we know that through media, the president makes a statement or the governor. How would people know why it's in that posture?
You're recognized.
Thank you, Mr. Chairman. And Chairman Martin, my presumption would be that the county website or the municipal website would be able to put that information out there. It would only be for government buildings within that particular jurisdiction.
Chairman, Representative Martin? You can't do that now. Representative Rudd.
Thank you, Mr. Chairman. Representative McCallum, you had said that only the president and the governor can do that now. Is that a federal or a state law? I didn't even know there was a law about that.
Representative McCallum.
Thank you, Mr. Chairman. And Chairman Rudd, I wasn't aware that it was not legal for our county and city mayors to do that until my county mayor informed me of that. So hence the reason I am here before y'all.
I'm just wondering, Mr. Chairman and Representative, if it's a federal law, wouldn't yours be in violation of federal law?
Representative McCallum.
Thank you, Mr. Chairman. I believe that the state has, the governor has the authority by state law, but the president has authority by federal law.
Any other questions for the sponsor? Seeing none, we're ready to vote on House Bill 1697. Moving on to calendar and rules. All those in favor, please vote yes on the board. Those opposed, vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board and announce the vote.
Mr. Chairman, you have 12 ayes, 10 noes, and 1 present not voting.
Bill moves on to calendar and rules. And item number 80. This is House Bill 1803 by Representative McCalman. Got a proper motion and second. I do not see any amendments on this bill. So Chairman McCalman, you are recognized on House Bill 1803.
Thank you, Mr. Chairman. And essentially, members, what this does is allow for a collaboration of distilleries. If they come together and combine their product, that they can sell that respective product, that blend from their distilleries. Currently, state law does not allow them to, since the entirety of said product was not produced at their distillery. And with that, I stand ready for any questions.
Any questions for the sponsor? We do have some speakers on this. Addison Russell, Matt Russell. Is either one in the audience? Seeing none, we'll move on. Matt, you want to speak? Only if needed. Does anybody need Matt to speak? Okay. All right. That settles that real quick. Any other questions for the sponsor? Questions being called. We're ready to vote on House Bill 1803 by Chairman McCalman. Moving on to calendar and rules. All those in favor, please say aye. Oh, here we go. See, y'all got me all frustrated. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 22 ayes and 1 present not voting.
Bill moves on to calendar and rules.
Thank you, Mr. Chairman and committee.
Item number 40. Item number 40. Huh? Okay. Item number 40 is House Bill 1664 by Representative Mayberry. Got a proper motion and second. I do see we have some amendments. Which amendment code would you like to run?
Thank you, Mr. Chairman. It looks like we are at 14163.
Okay, let me check on that.
Or is it 15709?
It's not my, oh.
I think the first one was the bill and the second one's the amendment, 15709.
The First Amendment rewrites the bill and the Second Amendment just amends it.
Okay, so yeah, I have 2 then.
Both of them?
I have 2, yes.
Okay, all right. All right, the First Amendment we're going to take up is 014163. Do I have a motion? Second. Proper motion and second on Amendment 14163. Without objection, 14163 will go on to House Bill 1664. All those in favor, please say aye. Opposed, no. If you'd like to be recorded, see the clerk. Your bill is amended now. We can take up item 15709. Or proper motion and second. Without objection, we'll place Amendment 15709 on to House Bill 1664. All those in favor, please say aye. Opposed, no. The ayes have it. You're recognized on your amended bill, sir.
Thank you, Mr. Chairman. Last year, the General Assembly passed legislation prohibiting discriminatory preferences in the state and local government. While those prohibitions were put in place, there was no uniform requirement for the entities to certify that they are complying with the law. That's what this bill is about, to make sure that there's an annual attestation that is filed saying that they're following the law. I stand ready for questions.
Right. First on our list is Representative Dixie.
Thank you, Mr. Chairman. So this would apply to school, like university schools, and what else? State offices, what?
Representative Mayberry.
Thank you, Mr. Chairman. Yeah, so the head of LEA, head of a college, or one of the representatives there, that was one of the amendments, the head of the city, the county.
Oh,
Representative Dixie.
so you said LEA, so would that apply to school board? So if someone were to put their finger on a scale for a person who is unqualified over a qualified person, and especially if the unqualified person was an adult star, would that apply to this?
Representative Mayberry.
This would go to the superintendent, and they are not in charge of school board elections.
Representative Dixie for a follow-up.
Oh, thank you. I was just wondering how, because that seemed like that was an obvious of a DEI appointment. So I was just wondering how they could not fall under this.
Representative Mayberry. Any response?
Renew my motion.
Okey doke. Next on the list is Representative Miller.
Thank you, Mr. Chairman. Attestation, could you define exactly what that term means?
Representative Mayberry.
Thank you, Mr. Chairman. Yeah, the formal act of witnessing, verifying, or certifying.
Okay.
Representative Miller.
So this verification, you're going to report to, who will you report back to on this?
Representative Mayberry.
Thank you, Mr. Chairman. This is going to go to the comptroller is going to be able to certify this.
Representative Miller.
You said the comptroller?
Representative
Only the
Mayberry.
comptroller?
Thank you, Mr. Chairman. The bill establishes a clear January 1 annual deadline for the submission to the attestations to the comptroller, creating a consistent statewide reporting process without changing the substance of the current law.
Representative Miller.
What would be the penalties if these reports are not submitted to the
Representative Mayberry.
comptroller?
Thank you, Mr. Chairman. This does not have penalties attached.
No penalties whatsoever?
Representative Mayberry.
This is overall to promote clarity, administrative efficiency, and consistent documentation of compliance across the state and local governments.
Representative Miller.
So if there are no penalties, if the entity, higher education or whomever, decides not to make a report because there are no penalties, why would they report?
Representative Mayberry.
Thank you, Mr. Chairman, so that we know who's following the law and who's not.
Representative Miller.
Okay, let's look at a potential report. What would be in that report? Based on what you are requesting in the report. For an example, if you take higher education, executive branch of that, are they to report, let's say, the number of faculty members that were not receiving tenure or promotions, or I'm just trying to understand exactly what would they be reporting?
Representative Mayberry.
Thank you, Mr. Chairman. Again, they're reporting based on the laws that were passed last year's legislation. Amendment 2, though, it does say the Attorney General and the reporter may investigate any allegation that a state department, agency, or other unit of the state government is acting in violation of the section or another state law prohibiting use of discriminatory practices.
Representative Miller.
So this is in reference to DEI?
Representative Mayberry.
So this is reference to the bills that were passed last year about discriminating preferences of diversity, equity, and inclusion. Yes.
Representative Miller.
Is this DEI, which is diversity, equity, and immigrations?
Representative Mayberry.
Thank you, Mr. Chairman. I just told you what it was, but no.
Is
Representative
diversity,
Miller.
equity, and inclusion. This is what the report is about. This is what you want the higher education, you want local government, you want all of these entities to submit to the comptroller a report saying that here are the number of females, African Americans, or any other ethnicity. We want to report how many received promotions or didn't receive promotions under certain circumstances.
Representative Mayberry.
Thank you, Mr. Chairman. No, they just want to report if they're following the law.
Representative Miller.
Okay, thank you, Mr. Chairman. I'm not getting anywhere with the questions, obviously. Thank you, Mr. Chairman.
Okay. Next on our list is Representative Powers.
Thank you, Mr. Speaker. I'm sorry, Mr. Chairman. Question on the bill.
Question's been called. We got 1, 2, 3. We got 3 hands. 4 will go on the board. All those in favor of the objection to previous question, please vote on the board. Madam Clerk, open the board. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 16 ayes and 6 noes.
All right. Objection fails. We're voting on previous question. Okay. Objection prevails. Previous question prevails. All right, we're ready to vote on previous question. All those in favor vote yes on the board. Those opposed vote no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board and announce the vote.
Mr. Chairman, you have 16 ayes and 6 noes.
Where's this going? Bill moves on to education.
Thank you, Mr. Chairman.
Item 41, this is House Bill 1666 by Representative Mayberry. Do I have a motion and second? Proper motion and second. Representative Mayberry, I don't see any amendments, so you're recognized on your bill.
Thank you, Mr. Chairman. This is a bill to put in place that, as introduced, includes honorifics to the prohibition and requiring a state teacher, state employee, state contractor to use a person's preferred name or pronouns. This expands that to honorifics. So that'd be like Mr., Mrs., and to those that are like mix, the ones that are not real. So Mr. and Mrs. is the honorifics were aligned to biological sex. Stand ready for questions.
You have heard the explanation of the sponsor. We have several people on the list. Representative Dixie.
Thank you, Mr. Chairman. Can you tell me the origin of this bill? Like, where did you get this idea from?
Representative Mayberry.
Thank you, Mr. Chairman. We have several teachers in our district that wanted to go by the wrong honorific. I have had multiple other teachers, students come to me about it. One teacher wants to be called MX, so MX Dot. The other teacher, another teacher reported in the district is a male, asking his students to call him Mrs. And so that's where the bill came from. It's happening, of course, all across the state.
Representative Dixie.
So if I'm not mistaken, and I don't want to call you, I don't want to say you're saying an untruth, but I think that the origin of the bill comes from you have a teacher that is a transgender that wants to be called Teacher B. That's where this comes from. And I don't understand why this is such an issue of respecting somebody, what they want to be called. If I want you to call me Vincent or Representative Dixie, that's what I want you to be called.
Representative Mayberry?
Well, no, I was just waiting till he finished.
Oh, okay.
Because I didn't want
Sorry, that had to do with education.
So
go ahead.
So when you hand somebody some power, when a man has power, it shows you what type of person he is. And we can only judge you by the bills that you bring. And your bills are some of the most hateful and derogatory bills that I've seen this year.
Stay on the bill, Representative Dixie.
This bill is very hateful. And so I don't understand why, if a teacher, and it's not disrespectful to want to be called Teacher B or MX, if that's what they choose to be called. What is the problem with that?
Representative Mayberry.
Thank you, Mr. Chairman. This bill has nothing to do with the person out there calling herself Teacher B. Teacher B would be an appropriate name under this bill. She has inserted herself into this conversation because I guess she wanted her 2 minutes in the spotlight, but it has nothing to do with her. She actually, I've learned, is not even a teacher in our school district, and she's come out. And I now have a lot of teachers reach out to me and saying, hey, we don't like her calling herself Teacher B because she's not a real teacher. She is a one-to-one help for our students. So it has nothing to do with that teacher. And she's been in my office multiple times. We have great cordial conversations. We've had great respect for one another. So it has nothing to do with that person.
Again, my
Representative
question-
Dixie, you're recognized.
Oh, sorry, Chairman. My question is, what is wrong with the person want to be called what they want to be called? And it's not disrespectful to them.
Representative Mayberry, you can answer if you'd like.
Thank you, Mr. Chairman. Objective truth is important. Reality is important. These are the most vulnerable amongst us, is our children. And what we teach and ask of our children is very important. And so in the state of Tennessee, I believe we need to make sure that we are standing on objective truth, and a male is a male and a female is a female. And our children need to know that and not get confused and have those thoughts introduced to them at a young age to confuse them for their future. So that's why this bill is coming forward today.
Representative Dixie, I'm going to move on to some other people. We can come back to you, but the list is getting pretty big. Representative Martin.
Thank you. First of all, Representative Mayberry, I don't see hate in you or in your heart at all. I might disagree with you, but that doesn't mean that you're filled with hate. My question about the honorific, if I am teaching a class, would this say that I couldn't require the students to call me Dr. Martin?
Representative Mayberry.
No, this bill would not have any bearing on teacher, doctor, coach, nothing like that.
Okay.
It's been reported in the media because of the person we referenced before had said it, but that doesn't make it true. This bill does not do that.
Representative Martin.
I'm good.
Okay. Representative Mitchell.
Yeah, thank you, Mr. Chairman. Well, I'm just did a quick Google search on honorifics. Several of us didn't even know what MX was until his bill here. But it also says common usage examples of honorifics, professional titles, doctor, professor, captain, sergeant, social titles, Mr., Miss, Mrs., MX, formal and honorary titles such as honorable, sir, your honor. So, judges, get ready. We're about to call you by your first name. Academics, PhD, dean, chancellor are all common examples of honorifics. So, I'm sorry, but he needs to narrow down his bill, because if he wants to go after MX or whatever group he's trying to poke in the eye and hurt, he needs to narrow down his bill, because he's doing a disservice to a lot of people who either are serving our country, serving our communities, serving our state, or serving our children in schools that went through many years of education to get those titles that
Representative
they've earned.
Mitchell, ask your
Thank you.
question.
Do you know what your bill does?
Representative Mayberry, you can answer if you'd like.
I do, and
Okay.
it doesn't do that.
Okay, next on the list is Representative Salinas.
Thank you. Reading the bill, I agree. It says preferred name, pronoun, honorific. And during subcommittee, I gave you examples where in my profession, coming from academia, where a professor has a different, calling someone professor means something. It means that that person is a tenured track. It's different than calling someone a doctor, even though they have a doctorate. And I think that this is such a disrespectful law to so many people that use different types of honorifics. And I think punching down on people, and I asked you, under this law, would I be able to call you Mrs. or Ms.? I wouldn't do that because I don't want to be disrespectful. But there's nothing in your law that would prohibit me from calling you Mrs. or Ms. because I could use whatever honorific I wanted. Is that correct?
Mr. Mayberry?
So this is a bill to make it where the one authority is not asking the ones under their authority to call them something that's not aligned to biological sex reality. So, I mean, you calling me something that's just you and me talking. A teacher, someone in authority, asking to have them ask their students to call them something outside of reality is where the issue is here.
Representative Salinas?
I think this bill really undermines the hard work of people, and it's disrespectful to many populations in our community, and it punches down on citizens. You have not changed anything between committees, the subcommittee and this committee. So it says honorifics. Any honorific is fair game.
All right, committee. We've still got several people on the list, but before I recognize that and start going all the way back around again, we do have a speaker on this bill. Is Miss Johanna Keelhan here? All right. Without objection, we'll go out of session to hear from our speaker. Out of session. Give us your name, who you're with, and you'll have 3 minutes.
Hi, my name is Johanna Cohane. I'm from Robertson County. Previously in committee, when responding to a question, Representative Mayberry explained that he brought this bill because of a teacher in Montgomery County who asked the students to use the honorific MX. The honorific MX is gender neutral and used in situations when the gender of the person is either unknown or irrelevant. It was first used in the 1970s. The M covers both Mr. and Miss, and the X indicates a placeholder or wild card. So in that situation you described with the teacher, their gender is irrelevant to the student. Their role of teacher does not necessitate either gender, and so the use of the honorific MX, while not common, is completely acceptable. You're making a law out of what is essentially a grammar lesson. Is this bill necessary? You have a limited number of bills to advocate for the people of Tennessee and Montgomery County. And you've used a precious commodity because one teacher made their gender irrelevant to the classroom. When I see you or other members of this body in the hall, I speak about you or the things that I see and hear in this building. I address you or refer to you as representative, chairman, leader, because they're earned. Honorifics like doctor and reverend are earned through hard work, training, education, and a body of work that says a person deserves this title. By saying a person's preferred honorific does not have to be used, you're legalizing disrespect of the work those who earn the title have done. And I'm guessing you're just thinking of it in terms of the gender neutral honorifics, but all these are also examples included in that. Mr., Miss, Sir, Lady, Madam, Doctor, Professor, Reverend, Excellency, Father, Elder. Now a person who has worked hard and attained a doctorate in mathematics and can rightfully be called doctor could legally be denied that earned title. A person who has taken on the calling of preaching to others and spreading their faith and done the work to be called chaplain could be denied that title legally because one teacher in Montgomery County thought their gender was irrelevant to the classroom and irrelevant to the students. It's funny that on one hand you have a bill on the House floor, well, it's already over with, to put chaplains in every school. And here you have a bill that would deny them that earned title. Please reconsider this bill that legalizes disrespect. Thank you.
Thank you for being with us today. Does any of the committee have any questions for our guest? Representative Powell.
Yeah, I have a question. And here's the thing about honorifics. Actually, if you think about all of honorifics, even if we're using, so say you didn't know me as a representative, you knew me as Mr. You would call me Mr. For women, it's different though. So it's already biased. There's a misses, there's a miss, there's a miss. So to me, it's the entire premise of this is biased by nature. So we have not invented, I feel disrespected because nobody calls me Mr. with any kind of sign that I am married, but yet women can. So I think when we start getting into like really digging deep into all of these pronouns, people have a right. If I wanted to show that I'm a man who's married and I want to invent a title for myself, I should be allowed to do that. Would you not agree with that?
And I would agree with that. And I think that's a good point. And I understand, thinking that you're just adding honorific to a bill that already exists with pronouns, but honorific has a different side to it because it is an earned title. To your point, for women, it can give away or give a sign to their marital status. But you also have to think about the other honorifics that are being ignored, like Representative Mitchell listed, like I listed, that have to do with education or an earned degree or a place of respect. And like I said in this, if I go home and someone says, hey, what happened at the Capitol today? And I'm speaking about you. I'm going to speak about Representative Mayberry or Representative Powell or Representative Bricken, or I'm going to speak about Chairman Crawford, or I'm going to speak about Leader Lamberth. I use those titles because those are the honorifics that you have depending on your place in this body. I won't have to do that anymore if I don't want to with this bill. It comes up a lot for women who have doctorates that are not actual doctorates, not surgeons or anything like that. But if they have a doctorate in something else, a doctorate in philosophy or something like that, there are a lot of people who do not like calling a woman a doctor if it's not an actual medical doctor for whatever reason that may be. And this bill will legalize that. It's come up a lot in the news. It's come up a lot in conversation. And again, this bill legalizes that for absolutely no reason other than a grammar lesson. And Representative Mayberry did say that in committee. I think it was probably when Representative Salinas was asking about originally the origin. It was because the teacher wanted to be called MX. But MX, that capital M can be Mr. or Miss, and that X is basically a placeholder like you have in algebra that we all learn in math. So it's a grammar lesson. It's not hurting anybody, but one of your 10 or 15 bills or however many bills you've got is being used to be aimed at one teacher in Montgomery County because they want it to be called MX. It doesn't hurt anyone, and this bill certainly doesn't help anybody. And it's just legalizing disrespect.
Thank you. Any other questions for our guest? Seeing none, thank you for being with us today. We will go back in session. And I will recognize Representative Mayberry.
Yes, I just want to say again, there was media reports out there. A teacher said some things. She was not even credible in herself because she wasn't even a teacher. Her description of the bill is what's out there. It's inaccurate. I renew my motion.
All right. Any other questions for the sponsor? Representative Powers.
Thank you, Mr. Chairman. Question on the bill.
Question's been called on the bill. We're ready to vote on House Bill 1666. Moving on to education. All those in favor, please vote yes on the board. Those opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 13 ayes, 6 noes, and 3 present not voting.
Bill moves on to education. All right. House Bill 1666 by Representative Mayberry. Do I have a motion?
67.
Let me rephrase that. It's House Bill 1667. Do I have a motion? Proper motion in second. I don't see any amendments. You're recognized on your bill, sir.
Thank you, Mr. Chairman. This came from the city of Clarksville. It adopts a tiered system of penalties for repeat violations within municipal ordinances by the same person within a 12-month period. Their goal is they have some people that have dilapidated properties that the fines are small. They want to be able to tear them up just so they can get their attention to get those things fixed. I stand ready for questions.
Questions for the sponsor? You've heard the explanation. Are there any questions for the sponsor? Seeing none, we're ready to vote on House Bill 1667. Moving on to Finance, Ways and Means. All those in favor, please vote yes on the board. Opposed, no. Madam Clerk, open the board for voting. Has every member voted? Does any member wish to change their vote? Madam Clerk, close the board, announce the vote.
Mr. Chairman, you have 15 ayes and 5 noes.
Bill moves on to Finance, Ways and Means.
Thank you, Chairman of the Committee.
All right, committee. It is 3:48. I know we have a caucus meeting at 4:30, and we can either stop and get a little break, or we can continue on to 4 o'clock and knock out a few more bills. Keep going? Keep going. All right. All right. I don't have you on my list, but I can't. Who else has bills that have to be? Pal, you lie all the time. He comes up to me every day and tells me, hey, I need my bills run. I need my bills run. Every day. You don't even have that many bills. You only got 10, man. Do what now? Who? Okay, let's pull up a Lankford bill, they said. 81. Going to get to address the new freshman. All right, House Bill 1463 by Representative Lankford. Do I have a motion, proper motion, and second? Representative Lankford, I don't see any amendments, I don't think. So you are recognized on your bill.
Thank you, Mr. Chairman. That's correct. There's no amendments. This bill would simply require the state of Tennessee to lower flags on December 7th each year in honor of Pearl Harbor Day. This came to us from a constituent that was up here on Pearl Harbor Day this past year. Noticed the flags were not at half-staff, and stand ready for questions.
You've heard the explanation of the sponsor. I'm sure there's questions. The chair will take privilege. I've got one question. Were you in the Navy? Is that what this is about?
No, Mr. Chairman, I was not.
Okay. All right.
You still got time.
Representative Martin?
Is that sunrise and sunset Eastern time? Because the state is divided between the central and the eastern. Could you pontificate on that?
Good question.
Yeah.
No answer?
Am I recognized?
You are. You are.
Thank you, Mr. Chairman. That varies. So this is only over the Capitol, so that would be Central Time where we are at right now.
Yeah, good answer. Yeah. Chairman Moon.
Thank you, Mr. Chairman. And what time would that be in Honolulu, please?
Representative Lankford, you're recognized.
I think we kind of like to keep it on this bill. We're in Central Time. Honolulu would be on.
Chairman Moon.
Thank you, Mr. Chairman. This has to do with an event that occurred on December the 7th, 1941. So it is relevant to the bill, sir.
Representative Lankford, be careful.
This bill specifically requires flags over the Tennessee Capitol to be lowered on December 7th.
We have a great question coming up. Go ahead, Chairman Moon.
I'll pass if you'll come back, Mr. Chairman.
Yes, sir. Representative Mitchell.
Yeah, thank you, Mr. Chairman. How How many U.S. servicemen died at Pearl Harbor on December 7th, 1941?
Representative Langford.
Thank you, Mr. Chairman. There were 2,403 Americans killed on December 7th, at Pearl Harbor.
Representative Mitchell.
Which ships were sank or damaged?
Representative Langford.
Thank you, Mr. Chairman. There were multiple ships that were sunk or damaged on that day.
Rep Miller. Bo Mitchell, excuse me.
What-
Representative Mitchell, excuse me.
Well, no, honorifics has been gotten rid of. What ship is is now the memorial? Okay, all right.
We're just
He
going back-
was ready
back and
for
forth.
it.
It's
He
the
was ready.
USS Arizona. I
All
mean-
right. All right. Thank
Okay.
you. Good job.
Yeah.
Representative Langford, do you have any final remarks on this bill?
No, Mr. Chairman, I would just appreciate support on it.
Chairman Moon?
Thank you, Mr. Chairman. I request we roll this to the first item on the next meeting.
Second.
If there be no objection, this will be rolled to the first item of the next vote calendar. It's rolled. Oh.
Okay.
We have a motion, we have before us a motion to adjourn. No objection, we are adjourned.